So let's talk about a really fascinating legal battle. You have four homebuyers, right? They've got a completely valid claim against a developer who just never built their homes. They even went to court and got an official order for a full refund. But then, when they tried to take that final step to actually get their money, the court shut them down. So how does that happen? Let's dive in and unpack the single, really surprising reason their case was stopped dead in its tracks.
It all boils down to this number, 4. Just 4 people. Can 4 people, even when they're 100% in the right, really force a huge company into insolvency? Well, the answer reveals a critical, kind of hidden rule in real estate law that, honestly, every single home buyer needs to know about.
To really get this, we're going to walk through the case just like a judge would. We'll start with the hard facts that nobody disputes. Then we'll tackle the big procedural questions. We'll weigh the legal arguments, look at what other courts have said, and only then will we get to the final verdict and what it all means. Okay, first things first, the facts. Before a judge can even think about the law, they have to get the story straight. What actually happened here? Who's involved, and what's the core problem they're trying to solve? And, this story is probably a frustratingly familiar one for a lot of people. Between 2007 and 2012, these 4 individuals put their hard-earned money into a project by Parsvanath Landmark Developers. But years went by, and the project just stalled out. It was never finished. So they did exactly what you're supposed to do. They went to the Real Estate Regulatory Authority, that's RERA, and they won. RERA ordered the developer to give them a full refund plus interest. But then the developer just didn't pay. So the homebuyers decided to play their final card, trying to force the company into insolvency.
All right, so the facts are clear. Now, if you're the judge, you don't just jump in and decide who's right or wrong. Nope. The very first thing you have to do is answer a procedural question. Does this case even have the right to be here? It's the first hurdle, and it's a big one. And this is that exact question right here. It's basically a gatekeeping question. In legal terms, they ask if the application is maintainable. All that means is, have the people filing the lawsuit follow the very specific rules they need to follow just to get their foot in the courtroom door.
And that brings us to this specific piece of the law. It's an amendment to the Insolvency and Bankruptcy Code, or the IBC. See, back in 2019, the law changed to give home buyers some serious power, the same power as big financial creditors. But, and this is a huge but, it came with a very important catch. They couldn't just act alone. So here's the rule, plain and simple. For homebuyers to file one of these insolvency cases, they have to team up. They need to meet a minimum number. Option 1, you get at least 100 homebuyers from that same project to file together. Or option 2, you get a group that makes up at least 10% of all the homebuyers in that project. You've got to hit one of those 2 targets. Now look at this. This is where the problem becomes crystal clear. In this project, there were a total of 488 homebuyers. So to meet that 10% rule, they would have needed 49 people to sign on. The other option was a flat 100. And how many people actually filed this case? 4. Just 4. From a judge's perspective, that's not just a small gap. That's a massive, glaring problem. So you'd think game over, right? Well, not so fast. The homebuyers and their legal team came up with a really clever argument. They knew about this numbers problem, so they basically tried to argue that the rule just shouldn't apply to them. Let's see how they tried to do it. Their whole argument was this. Look, we went to RERA. We have a legally binding refund order. That piece of paper changes everything. We're not just regular homebuyers anymore. We're now decree holders, which is a special legal status, kind of like a bank that's won a recovery case. So that rule about needing 100 people or 10%, that's for other people. It doesn't apply to us. It's a really smart attempt to sidestep the whole numbers issue. A judge doesn't just decide a case based on their gut feeling. They are guided, in fact, they are legally bound by what higher courts have decided in the past. It's called precedent, and it's the bedrock of how the whole legal system works. So what had the higher courts already said about this? Okay, so this gets interesting. The homebuyers' lawyers pointed to a case called Kotak Mahindra and argued it showed that having a recovery order makes your claim stronger. But the judge looked at it and said, not quite. That case was about a totally different kind of creditor, so it doesn't really fit here. But then, the developers' lawyers brought up a much more recent Supreme Court case, Vishal Shalani, and boom, this was the silver bullet. The Vishal Shalani case looked at this exact question and stated loud and clear that a RERA order does not change your status. You're still a homebuyer, and all the homebuyer rules, including the numbers threshold, still apply. For the judge, that was it. That was a definitive answer. So let's put all the pieces together, just like the judge had to. You've got the facts of the case, you have the clear rule about needing a certain number of applicants, you have the homebuyer's clever argument, and then you have a direct, binding ruling from the Supreme Court that speaks to the exact issue. When you lay it all out like that, there's really only one conclusion you can come to. The application was rejected. The judge ruled the case was not maintainable, which is just legal speak for saying it couldn't go forward. So even though their original complaint was valid, these 4 homebuyers were stopped right there at the courthouse gate. And the court's reasoning was just a simple, logical chain. 1. The numbers were way off. 4 is not 49, and it's definitely not 100. 2. This number requirement isn't optional. It's mandatory. You can't just waive it. 3. That whole creative argument about the RERA order changing their status, well, it was directly shot down by the Supreme Court. And 4, the court has to follow what the Supreme Court says. Period. You follow that logic, and you end up in the exact same place. The case has to be dismissed. So what's the big lesson here? I mean, this isn't just a story about 4 specific people. This ruling sends a really clear message for any homebuyer who finds themselves in a similar fight with a developer. At the end of the day, it all boils down to this. Numbers matter. When you want to use the powerful, and I mean powerful, tool of insolvency law, there is strength in numbers. A single, perfectly justified claim, as we saw here, is just not enough. The law requires you to act as a group. This chart really lays it out perfectly. Having your own individual grievance, no matter how real it is, that's the first bar. It's not enough. Going through the whole process and getting a RERA order in your favor, that's the second bar, and it's still not enough to get you over the line. To unlock the full power of the insolvency process, you absolutely must have that third bar, collective action. This tool was designed for a crowd, not a soloist. And so that leaves us with this final, really important question. Why does a rule like this even exist? Is it a fair way to protect companies from getting bogged down by a handful of frivolous lawsuits? Or does it end up creating an unfair hurdle that penalizes individuals, like these 4 people, who have very real legitimate claims but just can't find another 45 people to join them? It's a tough question about finding the right balance in the law, and this case throws that debate into sharp relief.